Hi everyone, I'm Brianna Schonenberg, an attorney in Husch Blackwell's intellectual property group. I focus my practice on patent and trademark prosecution. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. I will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the resources folder. This program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for the housekeeping items. Let's get started with our program. The topics we will cover today include why are you getting scam letters, how to spot scam letters, what to do if you receive a scam letter, what is being done about trademark scammers, and then we'll conclude with a case study looking at how paying a scammer risked the validity of a registration. So first, why are you getting scam letters? Well, the most obvious answer there is that your information is available online. And data miners know that. This is in large part due to the rules surrounding trademarks. For instance, applicants are required to provide their name to receive a filing date. They also have to provide a mailing address. You can see here at the USPTO's TESS database that the owner's name and address are listed for all to see. This is on the front page of a search, and a data miner can easily download all of this information into a database to create mailings. Next is that you have to provide email addresses. A recent rule that took effect in February of 2020 requires applicants to provide an applicant email address, which is different than the attorney's email address. If you're represented by an attorney, the provided email must be different than the email that's listed for your attorney. After they announced this proposed rule, there was significant pushback from trademark owners and attorneys regarding the heightened risk of scams and a lack of concern the USPTO was showing for owners' privacy. Eventually, the USPTO did concede that the email can be a unique email address created specifically for trademark filing purposes by the owner, or it can be created by their attorney. Originally, the rule did not allow an attorney to create this email address, so it was a pretty big concession. The USPTO also conceded that the applicant's email would not be listed in the USPTO's TSDR database to reduce data mining. However, if you go into the documents of record in the TSDR, anyone can pull the information from the documents of record. So here we see a screenshot of the TSDR database with the current owner information. You can see that the email address of the owner is not listed, but again, if they were to simply go under the Documents tab, they'd be able to find that. While it is possible to hide an owner's residential address, a mailing address must always be publicly available. So the residential address or domicile address is the one exception where the USPTO does agree to keep personal information private. To have an owner's domicile address be kept private, you have to file an application electronically, which is standard now, and the applicant must provide both a mailing address and a domicile address, and those addresses must not be the same. On the application form, you have to indicate that your mailing address and your domicile address are not the same. Note, however, that providing the domicile address on any other part of the form or on any other filing that you make with the trademark office will make it public. They do not check to ensure that a domicile address is not disclosed anywhere else. So ultimately, the information that's available to scammers includes your name, your mailing address, your email address, any phone numbers that you provide in filings, as well as the name and title of anyone signing your filings. A note on the phone numbers and the name and title: when we file applications, we often have clients sign the applications or the renewal filings, the declarations, because, as we'll discuss later, the filings need to be made based on the signatory's knowledge. And who better to know that a trademark is in use than the client themselves who's using the mark? Well, when we send out that link, often there's a blank box asking for the phone number of the signatory. That is not a required element for the filing. So oftentimes we tell clients to leave that blank to help protect some of their personal information. That said, some people add it, and again, that information, while not listed on the TSDR front page, it's going to be listed in the documents of record, so it is searchable. So scammers can send you physical mail, they can send you email, they can call you, they can text you, all with the effort of trying to scam you out of your money. Another reason and why you're receiving scam letters is that people are making millions with these scams, as we'll touch on later. So next, and probably the most important topic of today's discussion, is how to spot scam letters. I'll preface this section by saying that these scammers are intelligent and they are adapting. So today's tips may not apply to next year's scam. Overall, it's always important to closely review any materials that you're receiving regarding your trademarks. With close review, I'm positive that you'll be able to spot these letters. With that, let's jump in. Here's an overview of the key elements for you to consider when looking at communications you receive regarding your trademarks. We'll discuss each element more in depth. I'll add before we jump in here that each of the example letters shown in this section are letters that our clients actually received and sent to me questioning their validity. Consequently, they were convincing enough to warrant an attorney review. These almost fooled our own clients, potentially some of you on the call today. So first thing to look at is who sent the letter. Did it come from an @uspto.gov email? If it's an email that you received and it did not come from an @uspto.gov email, it is most likely a scam. Scammers are also using tricky names. They're using names such as Patent and Trademark Office, Trademark Compliance Center, Patent and Trademark Agency, Patent and Trademark Resource Center, United States Trademark Registration Office, Patent Trademark Register, World Patents Trademarks, Registration of International Trademarks. These are all so close to the official agency names. To help you, the USPTO does maintain a list of known scammers, which we'll see on the next slide. But to turn back to looking at who sent the letter, you also want to consider where they're located. The USPTO is located in Alexandria, Virginia. The letter shown here is from Bethel, Washington State. See how that's a bit tricky? Scams are also purporting to be coming from the European Trademark Office and WIPO. For today's discussion, we'll mainly be focusing on letters that appear to be coming from the USPTO. Note also that blogs have recently been noting that there's an increasing number of scams coming from Pakistan for some reason. So if you see anything discussing Pakistan, that's definitely going to be a red flag, and you can be assured that that's not an official letter from the USPTO. So as promised, here is an excerpt from the USPTO's list of known scammers. So as you can see, there are many bad actors out there, and these are just the ones that the USPTO is aware of. And this is just the top of the list of the solicitations originating within the United States. There's more to that list, and then there's a whole other list of solicitations originating outside of the United States. And this list is ever expanding. One helpful thing is that if you go to this website and click on the name of the party that you believe your letter was from, it will give you an example or two of letters that they're known to send, so you can visually compare it to the letter that you actually received. So next thing to consider is whether you have an upcoming deadline. Scam letters are most frequently received shortly after filing an application and within the 2 years preceding a maintenance filing date. Why? Because during those timeframes, you're actually expecting to receive information regarding your marks, so you're more susceptible to believe that the mailing is legitimate. That said, the deadlines that they state in the letters tend to be inaccurate, and they try to instill fear that if you don't act soon, your mark will be canceled. This is a frequent theory or strategy in scam letters. They try to instill fear and get you to act fast so you don't have time to consider whether it's legitimate or not. The inaccurate deadlines and the threatening text are usually in big, bold font, oftentimes in red. They're meant to scare you. The deadlines tend to, as I said, they tend to be inaccurate, and they tend to be early because they want to get to you before your attorney does or before the USPTO does, because the USPTO does send reminders to the correspondence address that's of record. So if you look at this letter, they state that you have a pending trademark cancellation, your trademark is about to expire, and that if not renewed in time, your exclusive rights to that mark may be terminated. So cancellation, expire, exclusive rights are terminated. Those are all scary terms to an unsophisticated or even a sophisticated person who owns a trademark. So what do you do if you don't know if you have a deadline coming up? As I said, they try to get to you before your attorney does. Some of these trademark deadlines are 10 years apart. So it may have been 8 years since you last spoke with your attorney on your trademark, and you've lost track of time, staff change, you don't know when that next deadline is coming up. Well, you should check the deadline with the USPTO's TSDR database or with your attorney. So here we have the TSDR database that you can look up your deadlines on. It's a very user-friendly site. It's accessible on the USPTO's website. You can just look up your application or registration number in the blacked out box there. And that number is usually found in the scam letter itself. So you don't need to go digging through your records. They'll give you that information for free. Then you just click on the maintenance tab, which is selected in the image here, to see your next deadlines. It will tell you what filing is up next, and it will tell you when the window opens for making the filing and when it closes for making the filing. And it'll also tell you when you've got generally a 6-month grace period. It'll tell you that as well. Most often, I'll see that the inaccurate deadline that's purported in the scam letter is the window open deadline for making a filing. It offers some sort of legitimacy to the date because it is an active, relevant date for your next filing, but it's not the correct deadline. It's when you can first start making the filing. But again, they try to get to you before the USPTO sends any reminders and before your attorney contacts you to try and trick you. The next thing to consider is, are the fees astronomical? So currently a combined Section 8 and 9 declaration and renewal is $525 per class, while a combined Section 8 and Section 15 declaration of incontestability is $425 per class. The letter here is charging over $1,600 for the first class and $850 for subsequent classes. That is 3 times the government fee for the first class. Assuming the scammer were to make a filing, which often doesn't happen, that is over $1,100 of service fees for the first class. In my experience, it is rare that attorney's fees are that high for a routine maintenance filing for a single class. Obviously, there are exceptions to that, but in general, that's pretty high to make a fairly routine filing. I will note that the $850 for subsequent classes is not necessarily unreasonable, but when combined with the amount for the first class, the amount is quite high. So another thing to look at is consider what they're asking you to pay for. Are they asking you to pay for publication? The USPTO does not charge for publication of a trademark application. Yet, this filing here is asking for over $1,400 to publish an application. Well, scam letters sometimes refer to this as a registration fee, and ultimately they're asking you to publish or register your mark with their private unofficial database. So they're asking for over $1,400 to publish in an unofficial database. That's a scam. I mean, you're not getting anything out of that. A note on this type of publication or registration scam is it's kind of a double scam. First, they charge trademark owners to publish or register their mark in this private database. Then they charge people to search their private database in theoretical trademark clearance searches or knockout searches. However, those databases only contain the trademarks that people paid to publish, meaning the search is incomplete, so you may file an application based on inaccurate search results, not having a full and complete picture of the existing marks that are out there. Next, you're going to want to consider how they're asking for payment. USPTO fees are paid directly online to the USPTO by you or your attorney. Scam letters most often ask for checks to be sent, wire transfers, sometimes credit cards. The recipient is sometimes a foreign entity. You can see in the bottom left corner here, there's payment details for a wire transfer to the Czech Republic. On the right side is a copy of a letter that asked for payment with a check within 10 days. So again, triggering that sense of urgency, trying to get you to not stop and think about the contents of the letter or what you're paying for. They ask for the check to be sent here to an address in Miami. So local, but again, not in Virginia. So definitely not legitimate here. Next thing to consider is you should read the fine print. These letters often contain explicit statements that they are not affiliated with the USPTO or any other official entity. They often state that this is not a bill or an invoice, or they say that it's an optional offer. Here, the letter we have says that the Patent and Trademark Office is a private company not associated with any official governmental organizations. This is an optional offer. This document is not a bill. But that information is buried in fine print under threatening text saying that your mark will be canceled if you don't pay soon. It has, again, that red banner, pending trademark cancellation, your trademark is about to expire. People are going to read the big bold text. They don't always read the fine print. But if the client that had received this had read that fine print paragraph, they would have noticed that it's not an official letter. Note too that sometimes clients have gotten confused. They expect an invoice from their attorney for trademark work, and one of these things comes in the mail. So that's another time frame where you might want to be on the lookout or have a heightened sensitivity to bills or documents coming in that relate to your trademarks. So another thing to look at If you're still unsure whether the communication is legitimate or not, is looking for grammar mistakes, typos, and fake hyperlinks or websites. Many of the individuals sending these communications are foreign actors. For example, we've talked about the increasing number coming out of Pakistan. And English is not the first language for these individuals, so the letters often contain mistakes. Oftentimes, the listed websites are also inactive. However, some of them do look legitimate. For instance, the big screen shown here is one of the publication scams, those double scams that we talked about a little bit ago. You can see how they purport to let you search their database for a fee. It looks pretty official. It has, a globe up in the left corner with WTP, trademark database. It's easy to believe how someone looking at this website might be confused. The smaller screen is from one of the renewal scams. So one that sends a letter saying you have a maintenance filing coming up. It's about to expire if you don't pay us now. They have a pretty official looking website with a governmental looking building in the blue and white. They've got a graduation cap. They've got an eye. They've got red, white, and blue. So kind of government patriotic colors to try and invoke a sense of trust that it's legitimate. But of course, as we know, it's not. So while checking the website is a good step, it's not always as informative as some of the other considerations that we've already discussed. Another thing that is not necessarily as probative as the other elements that we've discussed is, does the letter include the seal of the official entity that you expect to receive the document from? So WIPO, the USPTO, the European Trademark Office. You can't assume that just because a seal is present that the communication is legitimate, and we'll talk a bit about how the Trademark Office is dealing with that. So you start your consideration or start your review of the communication with the other earlier things that we talked about, but this is a good indicator of whether or not the communication is legitimate. So the tools we've talked about today are looking at who sent the letter. Do you have an upcoming deadline? If you do, you are more susceptible to receive one of these letters. Are the fees astronomical? Are they asking you to pay for publication, which, again, the USPTO does not require payment for? Are they asking for payment? Check, wire transfer, or red flags. You should always read the fine print. Usually it is explicitly stated in there that it is not an official communication and that it's optional, not a bill, not an invoice. Does the letter have poor grammar, typos, or fake links? And I recognize the irony in that number 7 does have a typo in it. Then does the letter include the seal of the official entity? So once you have reviewed each of these considerations, you should have a pretty good idea as to whether the communication you've received is legitimate or not. Just a note though, remember that not all scams are coming through email and physical mail. As we mentioned earlier, they, in some instances, can gain access to your phone number or email address. Some are coming through text messages. Read a blog recently or an article recently about an individual who received a text message that purported to offer logo creation services. They'd create the logo for you and then they'd file a trademark application for you, all for a flat fee. And it was a pretty low cost. So they said, yeah, great, sounds like a good deal. And they got deeper and deeper into a hole. The scammer promised lifetime maintenance of the trademark for a super low fee that is just too good to be true. And ultimately, the individual who fell for the scam started receiving death threats because they weren't paying their bills. It became a serious issue. Sometimes you find the scammers. So if you go to Google and search, how do I renew my trademark? Can someone create a logo for me? You want to consider the source and maybe look up the name of the link. Go to the tool, use the tools that we've already provided to you to assess whether it's legitimate or not. There are legitimate services out there, so I don't want to dissuade you from doing that type of search, but be aware and think critically about what you're doing. So what do you do if you actually receive a letter? And so you've gone through the steps we've already talked about. You're pretty confident that it is a scam. Well, first and most obvious is do not pay them. Seems pretty basic, but sometimes the best laid plans fail. In the case study we'll discuss in a little bit, there was a well-meaning individual that opened the mail and was not communicating with the individuals in charge of maintaining the trademarks. Thinking she was doing the right thing, she cut a check. In that instance, by the time we figured out what had happened, it was too late to cancel the check. But if possible, do try to cancel your check. In my opinion, it's better to pay the cancellation fee than allow the scammers to get your money. So if you're unsure about whether communication is a scam, one option is to send a copy of the letter to your attorney. I probably receive at least one of these letters a month from various clients asking whether it's legitimate or not. People are on the lookout for these, which is great, but I think it goes to show that these letters are very tricky, and a quick glance at it and does not reveal that it's a scam sometimes. Another option is to call the helpline of the USPTO or another official entity, so WIPO, European Trademark Office, whichever is relevant. The USPTO's number is available on its website. It seems obvious, but do not call the number on the letter for advice. They will try to convince you that the letter is legitimate because you're calling the scammer. As we'll talk about in the case study, calling them can lead to more problems. And it gives them your phone number if they didn't already have access to that. So definitely do not call the number on the communication. If in doubt, call your attorney, call the USPTO directly, look up the USPTO's phone number directly on their website. So if you're sure it's a scam, one thing you can do is simply throw it away. It's not going to hurt anyone if you just put it in the trash, don't send them a letter. However, if you would like to be part of the effort that's being made against these parties, you have a few options for reporting the scam. First, you can file a report with the Federal Trade Commission. This is actually recommended by the USPTO. The links to the reporting sites are here in the slides, and you can download a PDF of the slides in the resource tab with, I believe, active links. So shown here is the first page of the FTC reporting process. You can see that you would start by saying that the scam is an impersonator of a government entity. I worked my way through the reporting procedure. It seems pretty user-friendly, pretty simple to use, pretty quick. I will note that the FTC recently updated its reporting to allow people that have not fallen victim to a scam to file a report. This was not always the case, which seems contradictory to the FTC's goal of protecting consumers because it ignored a significant portion of those that received the letters. Ignoring people who were smart enough not to fall for the scam doesn't seem productive. As I mentioned, though, you can now report without having fallen victim to the scam, and that is a question that you answer in the form. So another option is to report the company to the Better Business Bureau. I looked a number of these companies up on the website for the Better Business Bureau, and quite a few of them have very negative reviews, as you would expect. I think the benefit here is that others can easily search these reports. So you help out, your fellow trademark owners by filing a complaint against these parties and leaving bad reviews. On the flip side, you can use this as a tool to check the legitimacy of a sender, because in some instances, someone else will have submitted a report against the scammer or bad review against the scammer. You can also inform the USPTO. This helps them add the name of a new scammer to the list that we showed earlier. It helps keep the list up to date and helps them understand how big of a problem this is. Another option is to alert your state consumer protection authorities. We'll talk in a little bit about how, in one instance, a state consumer protection authority was instrumental in getting one of these scams shut down. So one thing to remember, if you do decide to file a report, they recommend, specifically the FTC recommends, that you keep the letter and the envelope in case they need it. So a little bit of a risk there in that you keep it, you keep the letter. You don't want, again, some well-meaning individual to see it and think a deadline is passed and send a check, even though you've already identified that it's a scam. So maybe create a folder, something out of the way that's clear you shouldn't pay them, but something to consider. So you go through all the effort to submit a report. Maybe you do it with the FTC. You alert the USPTO. Will anything happen? Probably not, at least initially. The FTC clearly states that we cannot resolve your individual report, but we use reports to investigate and bring cases against fraud, scams, and bad business. So they may not help you individually, but you're helping the greater good in theory. The USPTO says that it's not an enforcement agency. They don't have the legal authority to stop private companies from sending these scams, nor can they sue or prosecute entities that defraud or attempt to defraud applicants or registrants. So, they skate over it by saying that they're raising awareness and working closely to combat the problem. But when it comes down to it, some of their own databases are the source of the problem. And as we talked earlier about their rules with respect to adding email addresses to the filings, it seems like they are not necessarily looking at this problem head on and truly addressing it. That said, there is action that's being done against these scammers. As I mentioned, the USPTO has really been criticized for not being concerned about owners' privacy with respect to the email addresses. Their database is open to the public. All information is publicly available. So some have been held accountable. In 2016, the operators of a private company called the Trademark Compliance Center, so again, tricky name, were convicted of money laundering in a trademark renewal scam. So those are the letters giving you inaccurate deadlines. In that case, they were sending out the letters, people sent checks, and they were not making any filings, and they did not have any intention to make any filings. These individuals had over 4,000 victims and made over $1.66 million. In 2021, the operator of two entities that were sending out misleading solicitations under the names Patent and Trademark Office and Patent and Trademark Bureau pled guilty to 4 counts of federal mail fraud. In that instance, they had a couple different bank accounts. They had a PO box. They had shell corporations. It was kind of tricky, but they had defrauded victims of over $3.67 million. And then finally, in 2010, the operator of an entity was convicted under the Deceptive and Unfair Trade Practices Act and the Misleading Solicitation Statute under Florida law. So again, circling back to the reporting as to why you might want to report the receipt of the letter to your local consumer protection agency, this is why. Your local agency might have more of an incentive to protect its local businesses and citizens than the FTC in a massive scam. In the Florida situation, they had over 1,400 victims and over $2.58 million that they had collected from these victims. Among these three, thousands of victims fell for the scam and scammers made millions of dollars. And there are many, as we said, there are many other bad actors out there. So a lot of money is being made through these scam practices. So one thing that the USPTO just did last week in taking a step against stopping these scams is they filed through the Department of Commerce a number of trademark applications for their own marks. So the USPTO filed trademark applications with the USPTO for USPTO marks. They filed, as I say, through the Department of Commerce. They were a little late to the game. There are quite a few other government entities that already have registered trademarks, so it was kind of surprising that this isn't already done. But anyways, the goal of this is to use the USPTO's registrations to have jurisdiction to go after these scammers in federal court for the ones that are using names very similar to the USPTO's name. Additionally, it gives them further options for taking down or transferring infringing domains. Having a federal registration is, evidence of ownership. So it gives them a deeper arsenal of tools to combat these scammers. That said, so these are the marks, and I apologize, one of them's showing up a little odd here. These are the applications that the Trademark Office filed last week. So 2 designs, 2 standard character. They've got USPTO standard character, United States Patent and Trademark Office standard character, and then 2 designs for USPTO and USPTO United States Patent and Trademark Office. USPTO says that these with an examiner, how they will overcome the genericness of at least the word mark for United States Patent and Trademark Office will be interesting. Did see in the past some third parties had applied for trademark office or trademark office agency, potentially some of these scammers, and they were denied for being generic. So interested to see how or whether these applications will be approved for registration. Nonetheless, it's an interesting take on, deepening their arsenal to approach these scammers and to stop and protect their customers. So in each of these 4 applications, they file, these are the description of goods and services that they included. Some of them I found to be directly, I think, aimed at using these registrations to stop scammers. For example, maintaining registries of trademarks, directly applicable to those that are doing the publication scam. They're also providing online searchable databases in the field of trademark applications, registrations, and title thereto. So interesting to see whether these registrations or these applications proceed to registration and whether they'll actually be used to stop any of these scams. But as I say, it's an effort, it's moving in the right direction. So Next, we'll talk about a case study of what happened to a client that I worked with when they paid a scammer. So here, as I mentioned before, this was kind of a too many cooks in the kitchen or a one hand not talking to the other situation. We had been working with a marketing individual for this client to find a suitable specimen for the renewal filing. In the meantime, someone else with the company opened a scam letter and sent a check. They fell for it. Before we could figure out what had happened, the check was cashed, so it was too late to cancel the check. Well, the client then decided to call the scammer, complaining about how the scammer had not made a filing that they had paid for. They left a voicemail, and in response, they received this email. It says, "Thank you for contacting us. Please find attached the confirmation that Section 8 has been successfully filed. Please accept our apology for the delay." So they made a filing, but there was a big problem. It was fraudulent. What the scammer had done was they had gone on the TEAS database and downloaded the original specimen that was filed with the application. Then they resubmitted it. So the filing from 5 years prior, they just downloaded it, resubmitted it, and then the scammer looked up who had signed the application. And it was a woman with, say, a title of CEO. And the scammer typed her name and her title into the filing and clicked submit. So the specimen itself was 5 years old. It was not evidence of current use. And they signed it in the name of an individual who wasn't them. On top of that, this woman was not even with the company anymore. So this was a problem. As I say, the filing was fraudulent. So for background and to make sure we meet our CLE requirements here, let's take a look at the relevant rules. So first, violations of the signatory rules under 37 CFR 2.193F says violations may jeopardize the validity of the application or registration and may result in sanctions. So we know that the signatory rules were violated, and we'll get into those later. So very clearly here, the validity of the application and registration was jeopardized by this fraudulent filing. So the signatory rules, by signing on a filing, so an application, a declaration, statement of use, the signatory is certifying that all of the statements are to their own knowledge true. So the individual, the scammer who signed it, had no knowledge that the trademark was actually in use or not. So that's problematic. Additionally, I'll note that there is a rule here that says that false statements are subject to potential criminal penalties, and we'll get into this 18 USC section 1001 in a minute. So next under these signatory rules is if you violate the signatory rules, you could be subject to sanctions or actions as deemed appropriate by the USPTO director. But the client was not the person who signed it inaccurately. It was the scammer. So we weren't too concerned about ramifications as to sanctions or criminal implications for the client, because they didn't actually they weren't signing anything. They didn't sign anything. They weren't the signatory. But again, that the signatory rules were violated, which jeopardized the registration, the validity of the registration. And we'll just quickly here. So this is the statute that provides criminal sanction or criminal implications for someone who violates the signatory rules. can be fined, imprisoned of not more than 5 years. I don't know if that's ever been the case. It'd be interesting to see whether the USPTO or has taken or has used this statute against any of these scammers. I haven't seen it, but I think it would be justifiable if they're making these fraudulent filings. They could point to this section to impose further fines or potentially imprisonment. So finally, this last rule here, looking at just fraud in the TMEP, fraud upon the USPTO. So under this section of the TMEP, if the examining attorney suspects fraud, they are supposed to bring it to their managing attorney's attention and then the deputy commissioner for trademark examination policy. This didn't happen to us in this case study, but because we were proactive about it and we're honest with the USPTO about what had happened. But wouldn't be surprised if the USPTO had caught on to this issue because, as I say, that specimen was identical. It was the same specimen that had been filed with the application. So definitely would have been a red flag, I assume, with an examiner. So what happened here? So the fraudulent Section 8 declaration of use was filed, luckily here, 2 weeks prior to our filing deadline for the maintenance document. So that gave us some time to figure things out. We learned that the USPTO blocks duplicate forms from being completed in a 24-hour window. So once we noticed that the scammer had filed a Section 8 declaration of use, we tried to go in immediately and file a legitimate one. And we weren't allowed to because the USPTO's database blocks it for 24 hours. So what did we do? Well, we called the USPTO. And they told us to send an email and explain the situation. So that's what we did. We tried to be very proactive. We knew that the USPTO is aware of these scammers, so we went on the theory that if we were open and honest with them, they would not penalize us, or invalidate the registration due to our client falling for a scam. And that was true. So we sent an email, and this is the response that we received from the USPTO. Of note is they indicated that the power of attorney ends with the issuance of a certificate of registration. So this was a Section 815 declaration of use and incontestability, and we had passed that registration. So they indicated that they would need an email directly from the registrant, and they had to request that the form not be uploaded. And they said that if they might not be able to stop the form from being uploaded to the record, but if they were able to stop it, the fees would not be charged. Here we had the client send an email, but they were not able, it wasn't in time to stop it from being uploaded. Ultimately, the client was okay with that because at least the scammer was charged for the filing then, so they didn't get all of the client, the entire portion of the client's money. Regardless, the filing is still of record. You can still look it up. So it's not a clean record, but I think in retrospect, we did what we could. And I think the USPTO, was more than helpful in resolving the problem. And then as soon as that 24-hour blockage for filings was released, we submitted a legitimate Section 8 declaration of use, which was accepted. So Trademark is still registered, everyone's happy, minus the client who wasted a few $1,000s on the scammer and then paid us more to obviously resolve the issue. But ultimately it was a good outcome. So lessons learned here. First is do not encourage a scammer to make a filing. If you fall for the scam and pay them, just bite the bullet and contact your attorney, make a legitimate filing. The situation got much more complicated once the client called the scammer telling them to make a filing. If they had never made a filing, we would have made our legitimate filing. Yes, the client would have been out a little over $1,000 for paying the scammer, but all things considered, would have been a much better outcome. If you do fall for something like this and a scammer does make a filing on your behalf that is fraudulent, I highly encourage you to contact the USPTO as soon as possible, and then also make a legitimate filing as soon as possible. We got lucky in that we had, as I said, that 2 weeks to make a filing. Would have been a different situation if that 24-hour period had been on the last day of the grace period. So we got lucky in that situation, but could have been far worse. So just a few final thoughts is I encourage you to look closely at all communications you receive regarding your trademarks. If it looks too good to be true, it is. If there are red flags, if it's saying that you have to pay now, it's probably a scam. So another thing is do your research. Look up the names of the entity that is sending this to you. Note that it's not only USPTO information or USPTO scams. There's foreign trademark jurisdictions, as I've mentioned a couple times, WIPO and the European Trademark Office. Some scams also in the kind of penumbra of trademark scams are logo creations. As I mentioned, trying to offer to create your logo and file it for you and maintain it for the life for a super low price. Too good to be true. It's not. It's a scam. Also look, and if you're doing your own trademark searches, pay attention to what database you're using. Don't want you to use one of these fake publication fee or registration fee, private publications or registrations. The search results you get are going to be inaccurate and incomplete. All problematic. So that is that's the end of my presentation here. So I'll see, I do have a question. Will you provide the slides and a video of this webinar? Yes, tomorrow you will be emailed a recording of the webcast for watching and sharing, and a copy of the slides is available in the resource center or resource link below. So if there are any other questions, please feel free to use the Q&A button. But thank you for joining today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use our feedback or your feedback to plan future programs that are applicable to your business needs. So with that, I don't see any other questions coming in. So this concludes our webinar. Thank you for joining us, and I hope you have learned enough to avoid falling victim to one of these scams.